Sorry about that.
Thank you, Chairman. Thank you, Chris. Director Carvajal, in the Corrections Act, the law required a risk and needs assessment system, and it was Congress's instruction that it was to be public. Indeed, it was to be available on the DOJ website. You guys responded with a program you called Pattern, P-A-T-T-E-R-N. You provided 2 reports on how Pattern would work. You gave us a committee staff brief on how it would work, and everything seemed to be going consistent with the law that we passed on a bipartisan basis. I've read in ProPublica a report that there's a new 20-page policy document that has supervened the Pattern program that has not been disclosed either to Congress or to the public. Could you explain what is going on there?
Thank you, Senator, for the opportunity to clarify that issue. I am familiar with that article, and I will tell you that the article was reference to a draft policy that was somehow released. It wasn't approved. It wasn't approved for issue. I will tell you that—
Are you following the draft policy now, or are you following the original Pattern program?
We are following the approved Pattern program, Senator. The Pattern is the DOJ's scientifically validated tool that assesses risk and needs within the Bureau of Prisons. They recently made some changes after receiving public outside stakeholder feedback and also with the Independent Review Committee. And what they did was make adjustments to it in order to remove any actual or perceived biases for people of color. And they did that because Pattern uses instant offense information, prior convictions, and it also uses institution adjustment. So
yeah, we're pretty familiar with Pattern because you briefed us on it. We just wanted to make sure we knew what the new program was. Let me turn to Warden Spalding's testimony from the Federal Medical Center, Fort Devens, in a case called Pena versus the United States. The warden testified, first he said that BOP, and I'm quoting him here, said not to use COVID-19 as a sole determination of reduction in sentence or compassionate release. Then he was pressed a little bit, and he went on to say, I don't consider COVID-19 as part of the criteria for reduction of sentence or compassionate release. And he testified that the exemption of COVID-19 as a part of the criteria for reduction of sentence or compassionate release was based on guidance from, quote, based on guidance from central office, which sounds like you. I'm wondering about that. And before you answer on that, I also want to add further testimony, which he did, which he testified to. He said central office sends down recommendations to review a specific inmate. If they don't meet the criteria or they do meet the criteria, and if they ask for us to send it up anyway, then I'm required to do that. The judge stopped him and said, you've been asked by the central office about a specific inmate who didn't meet the criteria, and he said, yes, sir. So when I put that together, it sounds as if there is not, at the institution level, the capacity to have COVID-19 be a determinant in the criteria for reduction of sentence or compassionate release, but that a name can be sent down from central office for review, I guess, for a waiver and exception to get around that policy. Was the warden testifying correctly? What is the situation here? I'll just put my cards on the table. It seems to me that this information should be going from the facility up to central office, not from central office down. And it makes it look like people who have connections can get the attention of central office and then get themselves considered for a waiver that the local institutions, folks on hand who are looking at prisoners aren't able to make. That doesn't seem fair or appropriate. Could you clarify that for me?
Thank you, Senator. I'm not particularly familiar with Warden Spalding's testimony, but what I will tell you is that we have procedures in place. The reduction in sentence and the compelling and extraordinary is the exact verbiage, and it is somewhat of a lengthy process. Keep in mind, Senator, that we make a recommendation to the United States Attorney's Office, who petitions the court the court is the deciding official of whether or not that individual gets a reduction in sentence. We have been using the home confinement method because it is quicker. And as far as giving guidance to the field, in order to quickly triage that 27,000 with COVID risk factors, we did run rosters in order to prioritize. And the criteria that we utilized was out of the Attorney General's guidance memos. So everything that we've done is out there on the record. There's no secret to what we're doing.
Mr. Chairman, my time has expired, but I would like to ask while we're here gathered in the committee, because questions for the record from the Department of Justice very often get ignored. I'd like to ask that the question for the record that I'm going to pursue on this to explain why the central office is able to do this and the local facility is not, what the considerations are for the central office and whom they determine should be sent down for this kind of review, and how this related to the Manafort case. I'd like to get the support of the committee in getting those questions answered rather than just thrown in the usual QFR bin.
Be glad to. We'll make sure that that happens, and I'll help you
I
anyway.
appreciate that, sir. Thank you very much.